Now, Mr. Armourer, we're ready to resume when you're ready.
Yes. Well, I found a paragraph in the Stocker and Stocker case.
Yes?
And it's paragraph 51, which can be found at page 1546 of the electronic bundle. And it is there that Lord Kerr says that he emphasizes again that it was a legal error on the part of the judge that has opened the door to a redetermination of the meaning of Mrs. Stocker's words.
Yes.
This is not a case of the appellate court giving precedence to its view of the court's recognition that the meaning determined by the judge was reached via a route which was impermissible, and having then to confront the question of what meaning should properly be attributed to the relevant words. Sorry. To the contrary, it is a recognition of the court that the meaning determined by the judge was reached via a route which was impermissible. So I'm submitting here that in respect of the first statement, the route that the High Court judge reached, along which the route along which the High Court judge went to reach the meaning was not correct. I'm submitting that the Court of Appeal found that it was not correct, and they made that finding in the paragraph that I referred to, and that is the same paragraph I referred to earlier, which is at page 1361 of the electronic bundle. Which is paragraph 29 of the Court of Appeal decision, which we were dealing with before the break. So in terms of going on to the second statement, similarly, the Court of Appeal found the second statement was not analyzed and the meaning arrived at by the High Court judge correctly, and that can be found at page 1364 of the reproduced record of proceedings, electronic bundle. And in particular, it is in paragraph 36 of the Court of Appeal decision. Where the Court of Appeal held that because the High Court judge took that expression bandit clan, let me be careful. The Court of Appeal said that that expression could only have been interpreted by the High Court judge in the way the High Court judge did, by linking it to the first statement. The High Court judge was not correct in arriving at the meaning that it referred to his family members as opposed to those persons with whom he shared a common interest, in other words, his political connections. And that is found at page 1364 of the electronic bundle. My submission is that it is only if that finding of the Court of Appeal can be challenged as wrong, that the meaning that the Court of Appeal has arrived at in respect of that second expression can be reopened by this body. And I'm submitting that the appellant in this matter is not saying that the Court of Appeal was wrong to say that the High Court judge in turn was incorrect in the way the High Court judge arrived at the meaning of the second expression. What the appellant in this matter is saying is that the appellant seeks to preserve or go back to what the High Court judge found, but the respondent is saying that what the High Court judge found was held by the Court of Appeal to have been arrived at on a flawed basis. And because it's not being challenged that it was incorrectly, the High Court judge was actually reaching that decision without applying the correct analysis or any analysis, the decision of the Court of Appeal or the meaning given by the Court of Appeal should stand. My lords, the approach of the Court of Appeal is dealt with in the, my lord?
Yes?
Was your lordship about to say something?
No, no.
Very well. The rule of the appeal court or any appellate court is dealt with in paragraphs 52 to 60 of the Stocker and Stocker decision, which can be, and those paragraphs can be found starting at page 1546 of the electronic bundle and going down to page 1549 of the electronic bundle. The conclusion is that when there is an identifiable error of law, an appellate court can intervene and make its own interpretation of the meaning of the words and substitute its own meaning for that of the lower court. I'm submitting that here the Court of Appeal was correct in identifying an error on the part of the High Court judge. I'm submitting that the lack of the application of the correct test, I have heard your lordships state that, or point out that the High Court judge did in a paragraph use the words that are used in the test. I'm submitting that those words, simply saying those words in an aside or in a paragraph that deals with other material is not actually applying the test. And I think that's applying the test involves a statement of the test and then the actual application of the test to the words in each case. And that did not happen in the High Court. The Court of Appeal agreed that that did not happen. And what we now have is an issue as to whether the Court of Appeal was wrong to say that the High Court judge did not apply the correct test or any test in determining the meaning of the meanings of the two different groups of words. I'm submitting that the Court of Appeal was not wrong. I'm also submitting that nothing has been identified to flaw the, to, no flaw has been identified in that process. And the appellant is simply asking for the decision of the Court of Appeal to be set aside without recognizing that the Court of Appeal identified flaws in the reasoning process of the High Court judge. And it was for that reason, having identified the flaws, the Court of Appeal substituted its own meaning for the words. The respondent, and the appellant in this case, has not gone through a process of stating why the Court of Appeal was wrong to do what it did. The appellant is simply asking for the reinstatement of meanings that were arrived at by the High Court judge without giving a basis for asking for that to be done. And I'm submitting for that reason the appeal should be dismissed. In respect of the quantum of the damages, my submission is that the Court of Appeal arrived at the meaning of the two sets of words. The Court of Appeal arrived at the meaning in respect of the 9 other statements, whether it's 9 or 8 or 10, and also identified that in respect of those words, the High Court judge did not apply a test to arrive at the meaning of those words. The respondent is taking issue with the Court of Appeal saying that or holding that those other 9 statements could have been taken into consideration. My submissions in respect of that are that the Court of Appeal was not correct in making that determination because the statements were made after the claim form was filed in the matter, and it's a matter of those statements being only possible to be relied upon as some form of possible aggravation. But before we even get to that stage, the meaning of the words needed to be arrived at. And the High Court judge did not do an analysis to firstly consider whether the statements, there's a presumption that each of the statements should be considered separately. And secondly, the High Court judge did not apply a test to say whether or not they should be considered together, and instead simply came to a conclusion as to the meaning of the statements taken together. And the respondent is saying that the High Court judge made an error of law in doing that. In 2 respects, the presumption that each statement should be separately considered. And if one, for instance, takes the second submission is that each one of them should have been separately considered, and secondly, in considering them separately, the proper test should have been applied. Neither of those things was done, and as an example, the statement that the appellant is referring to, the 9th statement found at page 1455 of the electronic bundle, that is an example of there being no reference to the appellant in it standing by itself. And that's an example of there simply being no basis on which that statement by itself could be regarded as adding anything to the case against the respondent. It's a general, I have to say, rambling diatribe about the political condition in Trinidad that does not mention the appellant. In respect of the quantum that was awarded by the High Court judge, I am relying on my submissions in respect of the quantum, the damages, and most especially in particular, the submissions in respect of the comments of the Court of Appeal, two of the Court of Appeal judges, in respect of remarks being made in the political arena. So both Justice of Appeal Rajkumar and Justice of Appeal Bulu Singh, now Chief Justice in Trinidad and Tobago, commented that the awards of damages in the political context should be carefully looked at, it shouldn't be large because of the damper on political comment. And I'm going to add here that these particular words in this case, where there is not a specific allegation of corruption, so in terms of if the chase levels were applied to them or an inquiry was looked at that, if an inquiry was carried out to ask which level of, at the chase level, these words fall, that's more assistance for the respondent's position that these words were emotional words in an outburst on a platform, blogging platform, where the respondent was intent on sensationalizing and attracting attention. And the High Court judge used words to reflect. She used the word rant at one point, and I am submitting, my lords, that the fact that this is agitated political speech that is described as a rant by the High Court judge, obviously, is not in the same level of an allegation, a specific allegation of somebody taking a bribe or somebody, a specific allegation of corruption, such as those were considered in the Moore FM case. And the Court of Appeal, having arrived at the meaning and realizing that it was a fleeting reference to Bandit Clan and associated with the PNM colleagues, the damages are to be set by the Court of Appeal. And if the Court of Appeal, considering all the factors, came to the conclusion that nominal damages of $10,000 should be awarded, I am submitting that that is what the award should stand at.
What do you say to the criticism that the Court of Appeal took no account at all of his aggravating conduct during the proceedings, repetition of the allegations in evidence, failure to making a plea of justification but then not providing anything to support it? On any view, was that not quite seriously aggravating conduct which the Court of Appeal simply make no reference to in their own assessment?
I agree that it's something that should be taken into consideration. I also know that the Court of Appeal regarded the actual words as, I think they use the expression, fleeting reference. So while I'm going, quite simply, there's the presumption, but I'm tempted to say, my lord, if it's not, in a way similar to the application of the test for the meaning, if it's not specifically mentioned, yes, there is a presumption that it isn't something considered. So on that basis, I will have to say that there is, if it's not mentioned, it means that it wasn't considered. And what we do need to consider instead is the expression, I know it's in there, what effect that would have on the quantum of damages along with the other findings of the Court of Appeal. So my submission is, yes, I can see that as something that's not specifically mentioned that is relevant, but there are also other things that should have been taken into consideration, that we can't expect all of them to be mentioned in the judgment, my lord, but yes.
What would you say we should do if we concluded that neither the judge's quantification of damages nor the Court of Appeals could be upheld?
Well, in my submission, it should be sent back to Trinidad, and it depends on the meaning that this tribunal believes should be used. In other words, is it the meaning of the High Court judge, or is it the meaning of the Court of Appeal judge? And there should be a direction to send it back to the relevant body.
Who is the relevant body?
In this case, I'm submitting that it's going to be the Court of Appeal, alternatively, Master of the High Court. But the Court of Appeal is the one that determined the meaning, and in my submission, they are the ones best suited to reconsidering the meaning of the expression of the words. In respect of, there were some matters that arose today. The usage of material to talk about insurance, what insurance brokerage firms do, I am submitting that that is not something that should be considered by this body. It is basically material that was not considered by the Court of Appeal. It is also extraneous to the relevant statements. The test that should be applied in interpreting each of the statements is clearly defined in the cases as being an impressionistic approach, and material outside of the statement should not be borne in mind or taken into consideration. So the question about what insurance brokerage firms in fact do, in my submission, does not arise. In respect of the entire exercise that was conducted by the appellant in putting over his case as to what the meaning should be, what meaning should be given to the different phrases, I'm submitting that that is exactly what the cases say should not be done. In plain language, I'm submitting that that was an over-analysis, an intellectual approach to the arriving at the meanings, which is exactly what is, it's the opposite of arriving at an impressionistic approach. Conducting an analysis as to what brokerage firms do as opposed to insurance companies do is not a sensible thing. And this adds to the respondent's point that somebody listening to this, the two groups of words, is going to come to the conclusion that it is rambling with the intention of attracting attention. That put your files in the road is not something that's colorful language. It's not something that is open to somebody picking up a dictionary and understanding it. Quite simply, it means physically putting an object in a road, and that of itself implies that it's colorful language. Of course, it's colorful language. And it's of itself, if we go down to the other parts, put your files in the road and it will be so bad that you have to leave. That is material that somebody would hear on the radio instantaneously. The persons later on interpreting that are not going to be, we're not present in court to hear Mr. Alexander giving evidence as to what the meaning of the words or what he intended. And there's even case authority to say what he intended to mean is not relevant to the interpretation of those words. It's a matter of what somebody hearing them live and direct, quickly sitting in their car, going to work, would conclude. And my submission is that they would conclude he is saying those things in order to attract attention, especially that first one, I'm going to put your file in the road, and you're going to be so bad you have to pack up and leave. There's no allegation about no specific allegation about anything being wrong. And then when you go to the second one, bandit clan, that expression of itself, colorful expression, and the judge took it and put on it the interpretation contended for by the other side without an application of what she should really have been doing to examine the meaning of those words. It shouldn't be what the counsel for the attorney, for the appellant, submits there. It's what the meaning is by somebody who is going to be hearing them quickly and moving on to something else. And the person who is going to hear those things quickly is going to associate them, number one, with the PNM connections, the political party connections, and understand it to be meaning somebody's benefiting from the political connections that operate in this society of Trinidad and Tobago, far-reaching all the many different ways. They reach into well, we'll save that for another day, yes. But
You say it's an ephemeral thing, but according to paragraph 16 of the judgment at page 1079, it was broadcast live on his Facebook page, but the judge says he caused it to be recorded and reposted it, thereby enabling its subsequent rebroadcast over social media, and he claimed to have approached almost 500,000 followers after he had posted the videos a few weeks later. I mean, is that correct? You accept that it wasn't just the instantaneous radio broadcast, but it is there on social media? I don't know whether it's still there, I would hope not, but it was on social media for a while for people to listen to if they hadn't heard the initial broadcast. Is that correct?
it is correct that it was on social media. What is not correct and not supported by the documentary evidence is the part about 500,000 followers, which is in the last sentence of that paragraph. In respect of who was able to see it, I'm asking that this court looks at the actual documents that were put in evidence by the appellant, on which there is posted the number of followers that were, or the number of persons who were viewing it. And let's see. I refer to it in paragraph 52 of my written submissions as to where it could be found. It will take me a while to find it, but basically there is documentary evidence submitted by the appellant with the Facebook posts, and on the actual Facebook posts, in the corner of those posts, is an indication of the numbers of persons who were viewing the webpage or who had viewed the webpage. And it was no way was it near 500,000 persons. It was in the double figures, in the thousands, my lady.
When was it taken down from his Facebook page?
My recollection is that it was taken down when there was an injunction given against him. I wasn't involved in the matter at that stage, and so I'd have to rely. I think Mr. Hackett was involved at that stage. I'm sorry to have to be relying on that, but that's my recollection. I stand to be corrected, but my understanding is it shortly before the trial began.
So that was 2 years after it was broadcast.
I am not sure, my lord.
No.
I do also want to say that that quality of the words, the main thing that on which the damages should be assessed is the meaning put on the words and the context in which the words were used. And I'm submitting that in the realm of political verbal abuse, I'll call it that, an award of damages of $10,000 is not unusual. It's quite simply I'm relying on the cases that deal with political verbal abuse, and that's so the Kermani against Survey and the Mundy and Askin, and yes, I will have to identify where those are. So the Kermani is at 22340 of the electronic bundle.
I'm so sorry. Could you give me that reference again?
2340.
Thank you.
And that case refers to the other case of Mundy, M-U-N-D-E-Y, against Askin, A-S-K-I-N, which is a case where a person on a political platform, one political commentator referred to his adversaries as vermin. And it was held that it was left to the jury to decide whether it was defamatory or not, but the case dealt with whether the correct direction was given by the judge dealing with the case in respect of that use of the word vermin. It was held that it could have been merely vulgar abuse, but it was left up to and not defamatory, but it was also possible for something to be vulgar abuse and defamatory, but it was left to the jury to make a decision. So I'm not seeing it on the list of cases, so I may have to send it. Yes. It's a New South Wales law report case.
And what is the name of the case which you're now referring to, the vermin case?
M-U-N-D-E-Y, Mundy, against Askin, A-S-K-I-N, and it is found at New South NSWLR 369.
Mr. Armour, can I just check with you about the numbers who saw the posts? I mean, looking again at paragraph 16 of the first instance judgment, the judge records that there's no issue as to the extent of the publication, and indeed it's the defendant's own claim to have approached almost 500,000 followers. So you said those figures are wrong, but they seem to have been the figures produced by the defendant himself to the court.
My lord, defendant says things that were not substantiated by documentary evidence, said things in cross-examination. So
So he was bragging about having more listeners than he actually had.
yes, that's, milady, thank you, that's a nice way of putting it, which is not necessarily accurate, which has permeated this matter.
But where in the evidence does your figure that you give in paragraph 52 of your case of 16,471 persons come from?
That comes from the prints of what is attached to the statement of case of the appellant in the High Court. I will get it.
It's at page 499. It's in the witness statement of Mr. Gabriel, paragraph 18, Roman numeral 1.
Thank you.
Thank you.
Paragraph 19, sir.
Yep. Yes, Mr. Alder.
So if one goes to page 39 of the electronic bundle, we see there my lords, I'm taking basically it's the attachments on these prints of the statements that has posted on it, actually on the documents, the number of followers. So that's
I'm sorry, where do we see that? On page 39?
well, page 39 has one of the Facebook posts, yes, but I don't think it's the actual one with the statement. So I was looking for the one with the statement on it. I am not able to find it, my lord, not at present. But it is in these groups of documents attached to the statement of case.
Yes.
I am not able to find them, my lord. But I do know it's those things. So for instance, if we go to page 75 of the electronic bundle, in the lower left-hand corner, there's a figure 38 shares. That's an indication of how many persons passed on the article. And I am encouraging your lordships to actually look at the documents that were put before the court. So for instance, on page 77, there's another one about 38 shares, a number of likes and comments. And that is the quantum, that's the size, those are the numbers that we are dealing with, that the respondent had as followers and people even looking at his what he put on his post, what he put on the Facebook. So this is not a situation of my client, the respondent, having a big following. His numbers were in the single figures even from the documents that were submitted by the appellant. This is their statement of case.
But I don't think shares aren't necessarily an indication of the audience. I mean, I don't think on any view, numbers like 38 or 41 are indicative of that on the evidence before the court. I mean, even on what you refer to in your statement of case, we were shown that comes from a witness statement which puts it in the order of 17,000 or 18,000. So I'm not quite sure what point you're making now.
Very well, my lord. What I'm saying is that the statement of the defendant, which is referred to in paragraph 16 of the High Court decision, is not accurate. He did not have anything approaching 500,000 followers, and therefore any court in arriving at the true extent of the publication should not be considering what he says, instead should be considering what the documents before the court can actually prove. And I think that's the most that I can say on that point.
Is that the end of your submissions, Mr. Armourer?
Yes, my lady, unless there's any question that anyone would like to ask me. It is the end of my submissions.
There don't appear to be any questions for you, so thank you very much, Mr. Armourer.
Thank you, my lord.
Mr. Mendes.
My lord, if I can just first of all provide a bit of information. First of all, with regard to the question when the video was taken down, Mr. Alexander himself says at his paragraph 31 of his witness statement at page 592 that it was taken down the following day after he got the pre-action protocol letter from Mr. Gabriel's lawyer. And he says, I was aware was settled, as far as I was aware was settled when the program was deleted from my Facebook profile. Therefore, the said video was only available for viewing by visitors to the defendant's Facebook for a period of approximately 24 hours. So that's what he says, and that has not been disputed. Mr. Gabriel had downloaded the video, and it had been sent to him via WhatsApp, and his evidence was that it was being shared via WhatsApp, and so that the only way of dissemination was not only on Mr. Alexander's Facebook page, but in other ways. The evidence in relation to the number of followers that Mr. Alexander has is in Mr. Gabriel's witness statement, as I pointed out, from page 499, and the figure of 500,000 persons actually is 500,000 views and not followers, as the judge said. And you'll see that at paragraph 20 of Mr. Gabriel's witness statement at page 500, where he says the defendant has also boasted of the fact that his posts and videos on social media receive a high number of views and are disseminated widely. Unsurprisingly, on March 14th, 2017, which is not long after the post we were concerned with, the defendant stated that I was able to get an estimated 500,000 views on a video recently, 370,000 on Facebook alone. No way to check WhatsApp. That's what Mr. Alexander himself said. In addition, on June 14th, the defendant posted on his Facebook profile that as at that date, his posts had received Facebook likes. That is the option which allows user to convey their approval of a person's posting, approximating 600,000 times.
But that's all his Facebook posts?
Yeah.
Is it not just these ones?
Well, this is, it's not clear exactly which one but he's referring to his Facebook post. Maybe
Yes.
it's all of them. My
But-
lord, it's impossible to know, of course, how many people actually
Yeah, sure.
read it or listened to the
But the 500,000 views, for instance, was some other video, nothing to do with this case.
could have been some other video. It could,
Well, there wasn't a video in our case, so presumably it was something else.
it could have been something else, yes. And of course, the fact that you have 16,471 followers does not necessarily mean that all of the followers read.
No.
It doesn't mean that the number of persons who viewed it would be limited to 16,400 persons because other persons who are not followers can view it.
That was the figure for one of his Facebook profiles, but in
Yes.
that paragraph they're listed as a number. Was it available on all of them? So we should combine the totals, or was it just available on the first one?
Well, the evidence was that, I think the only evidence was that it was available on his personal post. That would be the first one.
So that's the one with 16,471.
16,471 followers. But
Followers.
again, whether all 16,400.
No, no, sure, I understand the point.
Whether there were persons who were not followers who viewed, we don't
Yeah.
know. But that's the nature of the thing. We just simply don't know.
No.
But it certainly was, this was not the only medium by which it was shared. It was shared on WhatsApp. And Mr. Gabriel himself said that he had received it multiple times from different sources.
So, Mr. Manager, can I just check, in relation to paragraph 16 of the first instance judgment,
Yes.
your understanding is that that last sentence is a reference to what is being said in paragraph 20 of Mr. Gabriel's witness statement?
Yes.
It-
The judge says followers, but it really should be viewers.
Right, but my question is, there wasn't separate evidence from the defendant himself about this. One sees that paragraph 20 is Mr. Gabriel
Yes.
saying what the defendant has said, and that's the whole basis of this.
Yes, and it wasn't challenged in cross-examination, but Mr. Alexander did say in his cross-examination that he had more followers than the Prime Minister and leader of the opposition. And I can get that.
So this is just to give a ballpark figure of the scale of his audience rather than any identifying a particular number of people who saw the first statement or listened to the first statement.
Yes, again, as with newspapers, a newspaper would be disseminated, but you don't know actually how many people read it. You just know the extent of its circulation. But the difference with well, the newspapers are now on social media in any event, but the point is that these things stay there. There's no evidence that the second post, that is the Bandit Clan post, was taken down. So that as far as we know, was there. We don't know if it has been taken down or when it has been taken down, if it has in fact been taken down.
And I think you're going to give us an evidential reference for what the Mr. Alexander said in his evidence.
Yes, I was just going to try and pull that out. And give me 1 second, please. I had noted it as far as I remember. Yes, this would be at page 905 and 910 of the electronic record. My note is that he claims to be the most followed politician or social activist on social media. That was just my note of those 2 pages.
Thank you.
Yes, he says that on 905.
Yes. If I may just make one quick point in relation to my learned friend's submission that the Court of Appeal had found that the trial judge had not applied the correct test. The Court of Appeal had made reference to the decision in Stocker and Stocker, and the test to be applied when reviewing a decision of the High Court judge. And you will see that reference in a footnote at page 1355 of the electronic record. And reference is made in that footnote to paragraph 59 of the judgment in Stocker and Stocker, and you'll find paragraph 59 at electronic page 1549. And the passage that is quoted reads as follows. Certainly the trial judge's conclusion should not be lightly set aside, but if an appellate court considers that the meaning that he has given to the statement was outside the range of reasonably available alternatives, it should not be deterred from so saying by the use of epithets such as plainly or quite satisfied. If it was vitiated by an error of law, then the appellate court will have to choose between remitting the matter or, more usually in this context, determining the meaning afresh. If the appellate court would just prefer a different meaning within a reasonable available range, then it should not interfere. Now, there's nothing in the judgment of the Court of Appeal which says that the judge has made an error of law and therefore we are choosing between referring it back to the judge or deciding it ourselves. There's nothing indicating that they had intended to determine the meaning afresh. What it does say in the paragraph 29 that my learned friend referred to is that the judge was plainly wrong in the conclusion that the words used in the first statement were defamatory. So what they were doing was saying that her meaning fell outside the range of reasonable meanings. So that, respectfully, my learned friend is not right in suggesting that the Court of Appeal had, in fact, determined the meaning afresh. That is not what they were saying that they were doing. They effectively, by using the phrase plainly wrong, they were saying, as the guidance is provided in Stocker and Stocker, they were saying she fell outside the range. And of course, our submission is that they were wrong to find that her meaning fell outside the range of reasonable meaning. Finally, my lords, having consulted with my client for WhatsApp, I'm in a position to say that if your lordships are of the view that the trial judge's meaning in relation to the first statement should be restored, then I would ask that the entire assessment, including aggravated damages, be referred back to the trial judge for reassessment in the light of guidance given by the board.
Thank you very much,
Thank you very
Mr.
much.
Mendes. Well, we're most grateful to both counsel for the assistance that you've given us. We'll consider carefully the submissions that we've heard, and we'll let you have our judgment in the new year. In the meantime, the court will adjourn.